continues to say, demonstration or stoppage of work shall be deemed not to be a terrorist act within the meaning of the definition, so long as the act is not intended to result in any harm referred to in A1 to 4, which is the present case. On that date, materially, the court should take judicial notice that there was a countrywide demonstration pursuant to Article 37. As the court is winding up and retiring, Your Honor, we all come from different backgrounds and we all have things we do in life. I was once told by my grandmother that even a mortician has rights. For instance, those who work in mortuaries or places or funeral homes may picket and demonstrate when their workload goes down. What I mean is that when the mortality rate of Kenyans go down, Kenyans are not dying. Morticians may complain. The work of the Director of Public Prosecution is not an easy one. It is akin to that of a mortician. And there are our colleagues on that side. And I any person who was urging, I will not talk much about it because we are being led by senior counsel, and he's my friend. It was meant to be a joke, but everyone is serious. Today, the persons before this court, the persons who are intended to be charged, but tomorrow, they may be our heroes. I urge this court as it retires with the utmost humility, because now I'm like the EPP, I mean it. Count number 1, because we will come to discuss the other counts. As I had said on the question of jurisdiction, it is our position that on the second count and the third count, jurisdiction to deal with this matter under the CPC as Section 71. So these alleged offences were not committed within the precincts. Other courts which can deal. I know the DPP is itching to say that the Kikuyu court is not functioning. But there is another court nearby which can handle.
Referred to by Mr. Mwangi. Mr. Mwangi wants to convince you that there are two parts of that proviso that can occasionally deemed not be terrorists act within the meaning of the definite of the referred to in paragraph A, Roman 1 and Roman 4. Roman 4 is what is of our interest. He tells you that this should be the act of protest, demonstration, or stoppage of work. That is the act which the proviso is not to the banning, destruction, or anything. It's to the action that has originated. Why am I on the street? To demonstrate. I urge you to rely on the golden rule of statutory interpretation. It will not lead you to arriving to the absurdity and the mischief being actuated and perpetrated by the ODPP. The golden rule the golden rule, when it's used for interpretation, would lead you to arriving at a decision that when such an interpretation would lead to unreasonable or nonsensical results to which the DPP is inviting you to. I rest my case.
Yes, Your Honor. See for the strong words by counsel, especially Devonjiro here, about nonsensical stuff. I won't respond to that because I know that decision to charge is a very solid decision. And a lot of repercussions. And we have taken the decision bearing in mind the response. And especially also bearing in mind the current circumstances that we are all as Kenyans are undergoing. And just to, before I sit down, I just wish to say that there is a lot of misunderstanding on the import of the exemption.
Coming from?
Just give him an opportunity to respond to any.
I don't think he has audience, Your Honor, with due respect, and we wish to object to that,
Yes,
because we are now reopening the case. Fortunately, that is the rule, and the court must be bound by those rules. We can't make our own rules.
I understand.
Yes.
Your Honor, yes, I also
as much. And
understand, Your Honor.
also on the two limits. And when Mr. Mashira rose on his feet, I said to him, reserve anything that you want to say, and I'm not opening up for the prosecution to make any new submission.
No, yes.
And to leave it there.
You know, I am well guided, but I still insist that unless the court wants to make its own rules that governs proceedings, that this gentleman, the DPP, has no audience before you. And I would wish you to make a ruling on that, Your Honor. I make an application that will make a ruling on that.
Your Honor, with tremendous respect, the Law Society is here and we represent Mr. Devonjiro. We are asking.
Yes, Your Honor.
Yes,
and thank you.
Not to reopen any new issues.
Yes, thank you. Thank you to the Deputy President of the United States.
But Your Honor, until when shall we be intimidated by the
As long as you remain
Yeah, it's right.
Just to save time, The Deputy President, LSK, went into the realm of new matters. And therefore, once you go to the realm of new matters, it gives a remit to the DPP to address. But I'm not going to address anyway.
Yes.
Just a sentiment. The DPP, and that is what I was saying before I was told to say. Each other with a lot of professional courtesy. This is not between us, it's not between you. The matter only affects these people that are before this court.
So now I don't think that needs any response.
It doesn't need. That should not be allowed. Or only that you're not.
No.
In regard to Ms. Stiger
Yes.
and Peter, of course we'll be making the same application
Yes.
if we can simply proceed with those two.
Indeed, I think even for the time.
And in those two, we will mostly be adopted.
Good. So, the state is in agreement.
We are in agreement.
Call out the next part. So for the accused persons, it is 068 of 2025, they may be seated. Wale ambao wameitwa kwa kesi ya Daniel kwenye Israeli wanaweza kutafuta mahali hapo kazini. So call the next part. Those that are remaining, please call it out.
Criminal number 70, 2025, State versus Peter Kinyanjui, alias Sarah Wanjiko.
Yes.
They should be here.
Peter
Peter and Sarah.
Please call them. Please call them. Please let me have the files. Sarah Wanjiko. This is a fresh matter.
These are fresh matters.
And we are taking quorum. is the new council that is coming into Mr. Nguringa.
Yes.
Yes. DCP, Democratic. Party in coalition with several others, including those represented by Council. The Honorable Gachagua, Gavi. That we are seeing state high-handedness. Whenever they hear the name regarding Gachagua. I'm going to invite Council Kibe, Ngai, to highlight the second case haunted and charged with terrorism. And I therefore want to invite Wakili Kibe, because these two were even admitted as if they were Al-Qaeda criminals. Or Al-Shabaab. Encountered to peace.
By my language colleagues. So what we shall be submitting on is try to make some. Your Honor, apart from the and taking off from of the charges that are before this court. In Kiambu, miscellaneous criminal application number by the Honorable Mr. Honorable Gary Kiberu, the Chief Magistrate. Of Kiambu. Had made a similar application. That case in Roiro is criminal, miscellaneous criminal case number E. We shall make arrangements to furnish this court and the prosecution, if they do not have already, the said two rulings. In those two rulings, Your Honor, the summary is the offenses, particularly the particulars of the offenses, facing are exactly the offenses precipitated. They are arraigned before this court. There are in both those two rulings Your honorable learned colleagues, the chief magistrates, ruled that the prosecution had not tendered the required evidence or grounds. Your Honor, those two rulings under the jurisdictions of our country are appealable to the High Court by law at the instance of the prosecution. But Your Honor, the prosecution, because it is part of the executive under the Constitution, they appear under the executive chapter, only that it is supposed to be independent. They chose, instead of complying with the orders made by your honorable colleagues, they decided to deploy the anti-terrorism officers, ATPU, to invade the hallowed precincts of the court, and for all practical purposes, abduct those two accused persons for purposes of the current arraignment that is before you. Your Honor, it is unfortunate that yesterday we were unable to access our office, but since Friday, after they were abducted at Roiro and Kiambu law courts, I had an intention to bring an important authority from the House of Lords, known as Bennett versus Horseferry Roads Magistrate, a decision from England. Bennett versus Horseferry Roads Magistrate. I can't remember the other citation. But it is one of the most important decisions that could be applicable to what is happening here today. I can't remember the citation. I remember the name of the case. Bennett, B-E-N-N-E-T, versus Horseferry Roads Magistrates Court. Chief Magistrates Courts like you. We shall furnish that decision as soon as we are able. Your Honor, in that decision, the basic issue was this, that Bennett had been, was somewhere in South Africa. South Africa and the United Kingdom had extradition arrangement where you could extradite persons to England. You know, but without getting Bennett from South Africa, pursuant to the extradition treaty, they decided to do a basically to get Bennett from South Africa, get him to England, and charge him. Bennett challenged his prosecution on the ground that there could be and there cannot be lawful criminal proceedings pursuant to an unlawful and unconstitutional act. There can be there is absolutely no validity. In the ultimate, the House of Lords allowed the objection, Bennett. One of the best decisions one can read, and basically saying that, my senior counsel can read this again.
Yes, indeed, Your Honor. It's Bennett versus Horse Ferry. Horse as in horse. It's okay.
Horse Ferry. You can read the one.
Horse Ferry.
Your Honor, some of these passwords are for the family.
Indeed.
Just read it.
We celebrate technology, Your Honor.
Then it was his horse ferry of magistrates and another.
Horse ferry.
Horse ferry is like horse and ferry.
Yeah.
Magistrates quarters another.
Uh,
There was a 1993 All England reports at page 138 and 151 House of Lords.
Yes, my Lord. So that, Your Honor, the basic finding by the House of Lords in allowing the motion was that this prosecution had to be prohibited, not because the state had no evidence, and not because the prosecution did not have sufficient to charge Mr. Bennett, but it needed to be stopped. Because once the prosecution and the police in England engaged in unlawful conduct and unlawfully arraigned the accused person and abetting an illegality and the violations of the rights of the accused persons in terms of the protection of law, if such a prosecution were permitted to proceed. Accordingly, Bennett was discharged, not acquitted, in order to give the prosecution a chance. To arraign him to court in accordance with the law. And so that the court's hands are not stained with the blood and the illegalities, like the acts of abduction and violence that was witnessed at Rome. Your Honor, applied to this particular case, the issue is simple. The accused persons, once an order has been made, and it used to be civilized a long time ago, once an order has been made that a person has been admitted to bail, it must mean at the very minimum that that person must spend a night in their home, in their house. Otherwise, it would mean that the only choice that the magistrates at Roiro and Kiambu had was to agree with the prosecution. And if you disagree with the prosecution, we abduct within the same courts and bring somebody to committee. Is it called Kahawa or committee? This one. Kahawa. You and bring somebody to anti-terrorism court.
But the nature of the confinement, you're right to call it committee.
So that you,
Yes, I'm going to change country.
you have anything after me. So that, Your Honor, the issue, and it should bother the conscience of this court. Because what's the image that the prosecution and the police, anti-terrorism police, are projecting? That those people that we cannot prosecute on a low threshold of law, we take them to Kahawa law courts, the anti-terrorism law courts, on the same issues, on the same charges, on the same facts. My Lord, if that were to be the case and were to be permitted, it would mean that the critical gain under the 2010 Constitution in terms of ensuring that the courts are not an executive branch and an extension of the executive arm of government would have come back. The courts in Roiro and Kiambu did act independently. And so the accused person asked me one thing. Why is the state confident that monkey business that is not possible at Roiro and Kiambu is possible before the Kahawa law courts? You know, we beseech you to make it very clear by allowing our objections, by saying that Kahawa law courts is also part of the Kenyan judiciary and will do its duty to protect the fundamental rights of Kenyans. Your Honor, my learned colleague, Senior Amalwa, is showing to me the fact that the Judicial Service Commission actually issued a statement to condemn and object to the actions of the state and its officers that has precipitated the appearance of the accused persons before you. So that, Your Honor, from these facts, it is quite evident that the accused persons, they are armed with orders of the court, setting them free until the state has put its house in order with regard to the same facts that are before this court. Two immediate things arise. Number one, the only way to uphold the dignity and the authority of the judiciary and the courts must be by ensuring that once orders have been given, particularly against a specific group, the DPP and the police, those orders must be complied with. And a contrary action that the prosecution chooses, we shall not go to the High Court, we shall instead take people to Kahawa. You know, I had some objections to arrogance. Arrogance does not come worse than this. That you are required by law to go to the High Court, you choose not to go to the High Court, and you decide we are heading to Kahawa. Why? Because it is an anti-terrorism court. We shall get back to that. It is still a court in Kenya, my lord. Your Honor. Your Honor, the second part of these orders from Kahawa were these. The prosecution was beseeching those courts to complete investigations. That's why they needed their detention. And the rulings were based on the fact that the prosecution failed to produce the evidence as required by the law. Is it 24A? 24A? 36A. Under 36A of the CPC. That is the legal facts as far as this matter is concerned. This is Friday. You are sought for 21 days to complete investigations over those very same facts. So that, Your Honor, and here I'm speaking about abuse of court process and abuse of power. It is obvious that, and the law is, as we had submitted in Kiambu, that before a person can be lawfully prosecuted and take a plea, there must be a certain threshold of evidence that must be reached. The position in affidavit of the prosecution that is the subject matter of the ruling of 4th of July is that we do not have that evidence. And effectively, the courts were basically saying, let them be out. They gave conditions. You can have them every other day, twice a week, to complete. Nevertheless, here, because the prosecution and the state would hear none of that. They don't even have some respect for the High Court. Because the moment those rulings were made, only the High Court could vary that position. That if you wanted, you are dissatisfied with what those magistrates say, you needed to go and convince a judge of the High Court. Now these are such dangerous people that your learned colleagues at Roilo and Kiambu got it wrong, and we must detain them. That has not happened. And it is the reason why we say the arrest and arraignment constitutes abuse of power, and the charges that they have preferred and want to be registered before this court constitute abuse of court process. This, Your Honor, I beseech you not to permit the prosecution and the Kenyan state to do this. Because it would mean that the Constitution means what the police and the DPP says it means. Your Honor, under our law, the Constitution is written, we know its meaning, and in terms of dispute, it means what the courts have interpreted. If the magistrates in Roiro and Kiambu got it wrong, get another interpretation on the meaning of our laws from the High Court. Anything short of that would turn this country into a police state. And Your Honor, we cannot have so that, Your Honor, to get into those other 5 points, now that you have that background, Your Honor, it is important that we point out that for purposes of Section 4 of the Constitution, Kenya is a constitutional democracy. That is Sections 4.2. And it is a constitutional democracy in which the values and principles referred to in Article 10 applies. One of them is to ensure that there is protection of law and the Bill of Rights. We submit that in a situation where a serious issues arise as to what is the correct conduct for a constitutional democracy, you cannot be able to say you have valid charges. In short, Your Honor, therefore, we are beseeching this court to make a finding that in a constitutional democracy, like it was done in Bennett versus Osfery in England, this kind of state conduct cannot be permitted. Second, Your Honor, is the issue of Article 38. Your Honor, the issue of Article 38 is important because that is the rights that were being exercised on the material day, the 25th of June, across the country. And it is important, because my learned colleagues had said something about it, just for me to say that in the definition for purposes, I believe, of Section 4, there is a proviso that is made. Yes. Yes, there is a proviso that is made that that is Section 2 actually. That with regard to that where a protest stoppage of work, that there is an attempt that is made by the Anti-Prevention of Terrorism Act to make sure that this law would not apply to certain kind of actions of a political nature. Your Honor, it is our submission that this proviso in Sections 2 of the Prevention of Terrorism Act was meant to ensure that in enforcing, in the implementation of the Prevention of Terrorism Act, the state would not cross the boundary. Because actions that are genuinely and undoubtedly of a terroristic nature are punished separately from actions, any inconvenience, any destruction of property that happens in the course of pursuance of a political cause. That was the distinction that was sought to be made. And I believe, as I believe we've had this discussion previously with Senior Counsel Kalonzo Musyoka, the reason was simple. Why Parliament needed this proviso to be included. That we have it in fake democracies, starting with places like Uganda, where citizens engaging in legitimate political actions end up being charged with terrorist actions and in military courts. In this case, the closest they are getting is to come to a court that is supposed to deal with Al-Shabaab and other people dealing with dangerous things. Your Honor, this proviso is a logical basis for you, and I thank you for saying that you will take judicial notice of certain events, that the event of June 25, unless it can be categorized that throughout the country, that was a terrorist activity waged by Kenyan citizens across Kenya, there would be no basis to say some Kenyans who went to the streets on the same grounds committed terrorism, everybody else did not commit terrorism. The law must be rational. Because the day it ceases to be rational, it becomes impunity. You know, the related point, and which seeks to fortify Article 38, is Article 50 of the Constitution. This Article 50 of the Constitution, the ones that deals with the right to fair trial, issues to do with jurisdictions, a competent court, trial before a competent court. Your Honor, this is absolutely important for a very simple reason. Your Honor, for purposes of the trial, it must be done in an open court. Your Honor, the trial before an open court has got a very simple meaning. That an open court is a court that does not have extra security, that is easily accessible to the wananchi, and that deals with a matter of a civil nature or criminal nature, in the sense that these are law-abiding civilians of Kenya until they are found guilty. My Lord, under the Anti-Terrorism Act, the court that deals with terrorist acts in the Republic of Kenya is not a court that is truly speaking an open court. All of us, starting with myself, we were told to park my car about 4 facilitation, the facilities of an open court that is provided in Kahawa. Because in Kahawa we deal with terrorists. If for a minute it were to be accepted that people who are pursuing a political cause within the meaning of Article 38 of the Constitution will be tried in Kahawa, we shall not only make a mockery of our national security, we shall also end up weaponizing the law made for terrorists to deploy it against those that we think we disagree with politically. And that is where the issue of political persecution comes in. And Your Honor, we urge the court not to go back that road of weaponization of the judiciary against sections of the Kenyan citizens with opinions that inconveniences the government of the day. We've been there before. It was a catastrophic time, and the reason why the 2010 Constitution, last of the CPC, sections 42A of the Criminal Procedure Code, these sections, Your Honor, says it talks about the disclosure by the prosecution. 42A1 says, pursuant to Article 52J of the Constitution, the prosecution shall inform the accused person in advance of the evidence that the prosecution intends to rely on and ensure that the accused person has reasonable access to that evidence. 2 is the one that is most important. In the proceedings under the Preventions of Terrorism Act, the Narcotic Drugs and Psychotropic Substances Act, the Preventions of Organized Crimes Act, the Proceeds of Crime and Anti-Money Laundering, and Counter-Trafficking in Persons Act, the prosecution may, with leave of the court, not disclose certain evidence on which it intends to rely until immediately before the hearing. Then the other provision sets out. You know, why is this section important? This section is important for the simple reason that because terrorists are such dangerous people, that we read, it's a CPC, sections 36A. CPC, section 36A. Just sorry, 42A 32A, sorry. We were dealing with 36A, the other side. Yona, what is it about this section? Yona, what these sections is based on is because those specified and to national security, that despite Article 50 of the Constitution, to prosecute the case without availing of the that is an absolutely important issue. Because one of the most important safeguards, you get the materials for your trial. So when you try a terrorist,
purposes of record, by the two. One is arson, contrary to section 332 Penal Code. The second one is malicious damage to property. Of the Penal Code. The third one is robbery with violence. Nonetheless, Your Honor, this is a court file. I am very sure that the court has judicial notice on the public document. All I am trying to say, in the interest of time, is that the offences that the persons before you had allegedly been brought before the Kiambu court on a miscellaneous to have custody of them were serious offences than the offences that they have allegedly been brought before you for plea taking today. And I am not in any way saying that offences related to water are not serious. But the ones I have cited carry mandatory sentences that are extremely punitive. Your colleagues in Kiambu agreed in those offences with the respondents and afforded them bail terms. I am reading the National Police Service standing orders at chapter 15. This is at section 2 on detention of arrested persons. Section 2(2)(d). The import of this section, Your Honor, is to guarantee the enjoyment of the fundamental right to bail and bond of a person by a police officer. What the masked and hooded men and women wearing the Kenyan National Police Service insignia, who whisked away the two, failed to appreciate on that day is that the law was not on their side. Before arresting such a person, they ought to have made an apprehension report in section 37 of the CPC to yourself or any other magistrate within the definition of the Chief Magistrate's Act. To have the person remanded. That was not done. Your Honor, in Law Society of Kenya and 5 others, I am buttressing what Mr. Ibe Mungai was saying. In Law Society of Kenya and 5 others versus Kithinji and 5 others. This is a constitutional petition E. Your elder brother Justice Momuye your elder brother 373 of 2024. Vehicle that they use
while in all definitions, it was an abduction. To function objectively to safeguard as I wind up, because I also don't want my colleague, Mr. Degwajiru, say anything, to reconsider consider that decision as a final submission as you conclude to determine this matter with Tina.
Trial of offenses where they have happened and courtesy of the submission by the counsels for the defense, led by Senior Counsel Dr. Kalonzo Musyoka. Your Honor, there is need for this court to address that. You'll be charged in Garissa or Mombasa. So that kind of nomadism need to be discussed. And another room was arranged for that. So, Your Honor, I leave it. Right? Your Honor. Maybe you should clarify. The case numbers for which the accused person was charged. No, whenever the DPT stands on their feet or adrenal in line. And you are concluding. So I was at the tail end.
Tear gas canister was thrown in the cell. Where he was held in. An officer
Only 1 minute, Your Honor.
Yes, one
Just
minute.
to the circumstances of that shooting and killing were as they were on the 25th of June. That was 30th of May, sorry. But that's during the demonstration for Albert Gachagua. But that officer was not brought before any anti-terrorism court. Yet the circumstances fits and suits the definitions under Section 2 of the Terrorism Act. It tells you there is a double standard in the manner in which the DPP is executing these functions. Finally, in summary, the doctrine of exemption created by Section 2, which our land senior counsel, His Excellency Dr. Kalonzo, referred to, exempting protests from acts of terrorism underscores the necessity of distinguishing between peaceful expression and violent acts, thereby upholding democratic principles and protecting therefore would mean that the charge is stinking to the high heavens and that this
our forum from the Law Society has increased. We have Mr. Brian Musyoka.
Thank you, Your Honor. Been listening to submissions by the defense. And before proceeding to make submissions, I'd like to highlight, I think, one issue that has become content in these matters. Peter Kinyajui and Sarah Wanjiku before this court are facing the provides an exception and an article that is was on ongoing. what we do not agree with them is the act. And notices had been the act goes on and says within the meaning of this definition, as long as the act, now this is the part that the court should look at. In our charge sheet, we are saying that the harm is not intended to resort to any harms referred as to paragraph A1. You will see that any act that happens under the said provisions is exempted from a peaceful, protected protest. Now the act of terrorism, in a very plain understanding, or breaking it down to everyone to understand, it only transits to act once you cross the line under Article 37. The Article 37 is protected, and you are acting, and the demonstration started under Article 37. They crossed that line, and their action resorted to paragraph A1 to 4. Then terrorism charges began. Terrorism acts began. And from the word go, counsel for the defense was submitting from the bar. You've been given nothing. Nothing to show that indeed there were abductions.
Your politely, I think this is something in the public domain that you
You know what I was saying before I was disrupted. An abduction is a legal term. That was taken by the defense in support of an allegation that there was an abduction that transpired. When the two on section 37 of the CPC, but allow me to take you back to section 21 so that we can move. You know, section 21 gives the police the power to arrest. And the arrest at touching. Once you are touched, and then it goes up to confinement. You know, from confinement, then it gets to all means necessary. And from necessary, and this depends with the reaction of the person being arrested. You know, the law says that no greater force than necessary may be exercised. So there was an escalation from touch, but there was no all excess force that was used that was necessary, Your Honor, and that is our submission. And if indeed there was, now that becomes subject to trial. The defense or people alleging that more force than necessary were used, then the burden shifts to them to prove that indeed more force used than was necessary. So abduction, we submit, is a legal term that has legal interpretation, and what transpired is not an abduction, but an arrest. They've equally, submitted that there were other charges that were facing the two accused persons before this court. With all due respect to counsel, there are no charges that were before any other court in the Republic of Kenya. What they are quoting to you are miscellaneous applications for charging, and that is why they've not presented any charge sheets before this court, because indeed there was none. If they are candid enough, they would admit that what was there was a miscellaneous application. And after a decision was made, a decision was made to charge with terrorism, and they were therefore now transferred from to try terrorism from any part of this country. And the charges before you, Your Honor, brings the accused person at the scope of this court. Let me go to section 36, Your Honor, of the same CPC. It provides for detention, gives the police the power to detain people arrested without warrants. Section 36 provides for detention of persons arrested without warrant. Immediately after section 36, you've been told about section 37, that they are supposed to report the apprehension to a magistrate. You see the selective reading of the law. Of the OCS of the police station have, the responsibility to report that apprehension to the nearest court, And on 4th of July 2025, date of the arrest, which was on Friday, past working hours. The Constitution says that this apprehension and if the 24 hours falls outside the working hours, then they are taken before the court at the end, before the end of the next court sitting day. On Monday, the 7th of July, they were arraigned before this court, and the court was informed of the arrest and the matter after arraignment. there is no impropriety, illegality, or abduction. Consequently, from the arguments of section 36, 37, and the Constitution, other that having been said, Your Honor, the two individuals before this court, you're told that they are party leaders. We are not here because they are party leaders, Your Honor. We are here because a charge has been approved. And the jurisdiction of terrorism charges I can say that they are being profiled before a court that is not sufficiently equipped to give that decision, since the decision, the ODPP decision to charge at a portal. Your Honor, in legal terms, what they are telling you is, can their decision be reviewed judicially? And if that is so, if that is what they're asking, Your Honor, the court that is equipped to deal and to check any excesses in terms of whether the decision was appropriate or not is the High Court on judicial review. Therefore, any argument as to whether plea will be taken or not, Your Honor, whether the charges are appropriate or not, cannot be legally and sufficiently be handled before this court. And a decision to charge having been made, then the plea, the most appropriate lesson to take is to allow, Your Honor, the plea to be taken. The remedy under judicial review does not subsist the plea taking until the trial is completed. Your Honor, there are some few issues that have been raised about Kufeni nyote nyinyi nyote such sentiments, Your Honor. And unfortunately these are sentiments for the defense. We do not know whether they intend to swear any affidavit to that effect, since information from the bar is a legal force of law unless it's submission. That information has to be communicated in a format known as an affidavit and not through hearsay from the true defense counsel, but by the person who was addressed. And I'm very concerned that counsel can submit as such. If indeed there was a police officer who did that, that is an illegality that we cannot even entertain. Let them follow the right channels so that we split politics from law. And finally, as I sit down, legally, Your Honor, there is nothing presented by the defense, whether constitutionally or through submission, that has raised reasonable grounds, Your Honor, to stop plea taking. The issue as to whether these are the appropriate charges or other appropriate charges should be preferred, Your Honor, is not an issue that can bar plea taking. And we wish the court to find that the charges are before this court. These people have been registered appropriately within 24 hours, and plea already taken. I have two colleagues, Your Honor.
Your Honor, just to buttress the point of my senior colleague, and I will submit on the issues in the application that is being made by my senior counsel, Mr. Kibe, on the issues of whether the rights of the arrested persons were infringed when they were being arrested. Your Honor, these issues would have been raised under Article 89 of the Constitution. And so, counsel should be telling you that his clients were denied counsel, or they were not brought before this court within the 24 hours rule as stipulated by the Constitution, or they were denied counsel, or other issues that are outlined in Article 49 of the Constitution. Those are not issues that have been brought before you. And if they were to be brought before you, or as counsel has said that they were abducted and not arrested, this court, then the question should be, can those answers be answered? But can those questions be answered by this court? And I say, interpretation of law, especially with regards to breach of rights, fundamental rights under the Constitution, can only be interpreted by the High Court. You look at Article 165, the Constitution, sub-article, that is B, it speaks to the jurisdiction of the High Court and says jurisdiction to determine the question whether a right or a fundamental freedom in the Bill of Rights has been denied, violated, infringed, or threatened. This is to say, this court has no jurisdiction to entertain the application by counsel to determine a question of infringement of the rights of the arrested persons. And why are we saying so? Because when counsel alleges these matters from the bar, are we allowed to cross-examine him? Because these are issues that he brings from the bar. Can we put him on the dock to cross-examine him? So this question is a question of trial, requires evidence, requires affidavits, requires to ask to be given an opportunity to respond, because now the blame is on the police officers who are allegedly abducted these individuals. Therefore, Your Honor, we are just saying simply, the issues that are before you are very simple, and they have very, very simple answers. But one, on the issue of whether the charges are proper, we have already submitted, and our position is, yes, they are properly brought before this court. And on the issues of whether the accused persons are properly presented before you, those are issues that cannot be litigated here. They have a recourse elsewhere. The accused persons are before you, and they are properly presented before you, and we have supplied them with the charge sheet. And Your Honor, you should allow us, this court should allow us to proceed and the accused person take plea.
Your Honor, I wish to adopt the submissions of my senior and my colleague. I believe we have given sufficient grounds as to why we are charging with these counts, with these charges, Your Honor. We also submit that this is the proper, we use the proper channel, this is the proper court to present these charges. We do acknowledge Article 37, and we do respect it, Your Honor. The issue at hand is whether there was a commission of a terrorist act. We wish for the court to look at section 2A, 1 to 4, Prevention of Terrorism Act, which provides to when a protest, to what actions can lead to a protest being regarded as a commission of a terrorist act. From the particulars, it's quite clear, we've articulated all of them. There was destruction of property and among other issues. We submit that the charges are proper. The elements of the charge have been articulated in the particulars of the offense. We say that you do allow us to proceed in taking, and the issues of evidence can be dealt with later, where we can be able to show that we were able to use the decision to charge guidelines to make this decision.
Your Honor, before I speak to the defense, I would also wish to raise a concern. As we are proceeding and making legal arguments before this court, one of the defense counsel, Mr. Ndegwanjiru, advocate, in his Twitter handle, @Jiro Advocate, was busy texting our names on social media and generating a debate, and the title, Your Honor, of the said Twitter is weaponization at its best. He proceeds to say that 3 counsel appearing for the state are weaponizing this process. Your Honor, for me, I take that as an incitement, and I do not take it kindly. And this counsel should be reprimanded, Your Honor. And it should be one also, that should he incite public to generate any reaction, then he should be answerable, and the court should, and the court should take notice of that.
Can you just allow the counsel?
Yes. And Your Honor, this is a post that was done at 11:12.
You know, am I required to respond?
And also amended and reposted again.
Yes, Your Honor, I do not believe that those are issues under the trial. Yes, I did it in exercise of my rights. Counsel stated their names in the glare of the public and the media. And if I am right, Your Honor, I would wish to restate the said names so that the record may read correctly. Yes, I think we are dealing with Ms. Wangoi, Ms. Mashira, and Mr. Kamau as the counsel appealing for the BPP. If I am wrong, Your Honor, then you can correct the record so that I can edit my tweet.
What about weaponization? Just read the entire Twitter.
Yes, it's there. It's not an interpretation. You can bring an affidavit and respond to it appropriately.
Your Honor, from the Law Society, this is maybe an issue that they can deal with internally in the Law Society. Counsel for DPP has alleged severally that you don't have jurisdiction on everything, probably including this. We can deal with it from an NSK level so that we move on. And by the way, it's something that can be resolved.
I hear you, Counsel Kabata.
Yes.
Now, I do agree that the statements that have been made by Counsel have been brought to the court's attention, and Mr. Bashir, you highlighted them. I think not for the court to take any particular action against this injury, but the court to note that that has been done. And that therefore, Mr. Bashir, you have a statement which is on the platform, and for what that is worth, you will know how to pursue that.
Most of it.
Just to say that again, that we court makes a determination of this. Why don't we allow the process to run its course? Thank you. So that
Absolutely.
Yes. Your Honor, I wish to agree with my learned counsel from the DPP that the term abduction is a legal term that ought to be used in the technical sense that it means, and particularly for purposes of judicial proceedings. Your Honor, articles, no section, Your Honor, under section 250, the word abduction, or the offense of abduction, is induces any persons to come from any place, is said to abduct that person. Any person who by force compels, that's the first part, or by deceitful means induces any persons to go from any place, abduct that person. That is section 256. In the circumstances of this case, we are relying on the first part, the use of force, which was witnessed during the so-called rearrest of the accused persons before you. Force, and now to present them before this court. Your Honor, we have gone, the definition, I believe my learned friend from the other side, the GP, Maura Kabata, defined to the court how an arrest should be conducted and pursuant to a reasonable apprehension that an offense has been committed. All that is on record. The point that requires emphasis is that the accused persons had been, let's assume they had been lawfully arrested. They had been lawfully arrested, but in the course of processing bail, pursuant to court orders, they were grabbed from the registry while processing bail. Clearly, this was done not pursuant to any apprehension, but to defeat the orders that had been made by your learned colleagues. You can say there is nothing technical that can be able to enable any person using common sense and blessed with reasons by the Almighty God to interpret it any other way. That you are grabbed from the court registry to defeat the orders of the court setting them free on board. In the case of Bennett versus the Hospital Roads Magistrates Court, the issue was precisely that if you ought to have brought Bennett from South Africa pursuant to an extradition order. And that order was not there. The court actually said, we cannot allow people to be tried in English courts. People who have actually been abducted. Actually, the truth of the matter in Bennett's case, the discharge was on the basis that he was abducted. In the context of this case, and the law has always meant the Constitution, the statute, promulgated rules and regulations, and judicial decisions of the court, and judicial orders. There was a judicial order setting them free. Over the same facts, the prosecution, I was waiting for that. The prosecution, I concede. If these two accused persons had committed terrorism act in Mandera, and Garissa, where this terrorism is actually perpetrated, it would have been a different ballgame. But it was the same offenses, the same set of facts. So the courts had said that there is no basis why your rights under Article 49 should be derogated, because that was the issue. Whether the DPP and the police justify the derogation of fundamental rights. Those magistrates say there were no grounds for derogating their rights and to ensure that they were further detained. Accordingly, any attempt to arraign them before you in disobedience of court orders and to defeat the proper administration of justice cannot be countenanced under the principle laid out in Hospital versus Magistrate and in the Gedongori case, because it was the same case, abuse of power. Abuse of power cannot be countenanced, cannot be tolerated. Your Honor, the issue, you are told that there were no charges that were facing them. But you would read all the affidavit. And that is a specific argument that was made both in Kiambu and Roiro, where I was there myself. They said, we are holding these people on the basis of specified offenses. Mr. Maura Kapata had read you. Robbery with violence, assault, all these kinds of things that are being cited today. And the issue for purposes of Article 49 of the Constitution is not the charge sheet, which is a legal document. It is, what are the offenses against this man and woman? The offenses were set out in an affidavit. So when today you are told we have a charge sheet specifying a terrorism act, this is a fiction used to justify disobedience of the law and to justify abuse of power. Because if it is permitted to proceed as such, and that is a bigger question, the courts would effectively have lost control over the persons brought before it for purposes of any prosecution. Your Honor, you are referred to certain provisions of the law. There is this issue that has repeatedly, you've been told, oh, we are seeking judicial review of the decision to charge that has been made by the DPP. There is no doubt that the DPP can make decisions to charge. You must be satisfied that you have jurisdiction.